Duterte-Trillanes saga continues. On Tuesday, the Supreme Court denied Senator Antonio Trillanes' petition for an injunction against the withdrawal of his amnesty, saying the Makati City Court should be the one to decide on the legality of President Duterte's Proclamation 572. Now, while Duterte has given his word that there will be no arrest without a warrant, the embattled lawmaker isn't trusting him, saying at the Senate. The issue is a hot topic among political observers and legal experts. So tonight we ask, is the revocation of Trillanes' amnesty valid? Hello, I'm Mikey Orata and you're watching Square Off, Season 16, The Firm Debates. Warning.
Well, malapit-lapit na po na makapakulong muli itong si Trillanes.
President Duterte ordering the revocation of the amnesty of one of his fiercest and most vocal critics, Senator Antonio Trillanes. The news broke while the president was on an official visit to Israel. Reporters got wind of the news hours after Proclamation 572 was published in the newspaper. That had been granted by former President Beda to Trillanes and several other soldiers in 2010 for the 2003 Oakwood Mutiny, the 2006 Marine Standoff, and the Manila Peninsula Siege in 2007.
This proclamation declares that the grant was invalid and void ab initio right from the beginning.
At first, the issue was that Trillanes supposedly failed to submit a sworn application and a sworn admission of guilt.
Hindi ako bibigyan ng amnesty kung wala akong application. Kung hindi ko na-fulfill yung requirement.
Now the president said Mr. Aquino erred in letting the then defense chief who was there, Gasmin, sign the amnesty.
It is not possible to do that. Why? Because an act of pardon or amnesty is an act of state. It cannot be delegated to anybody but to the person of the president himself.
The issue caught media attention on a global scale, with some outfits likening it to the fate of another Duterte critic, Senator Laila de Lima, who's been detained for 18 months over drugs and other allegations. Critics are up in arms over what they describe as an illegal and unconstitutional order.
It is the burden of the president to find a way to nullify that contract. And so he cannot unilaterally violate that contract. He has to go to court first.
The fact is, all the basis, the correctness of the amnesty was already ruled upon by the RTC when the RTC dismissed the cases against him on the basis of the amnesty.
Amnesty, which obliterates past offenses, is final, absolute, and irrevocable, unlike a presidential conditional pardon.
Malacanang, for its part, insists that it has the basis to revoke the amnesty and that the move is not colored by politics. So is the revocation of Senator Antonio Trillanes, the third amnesty, invalid? Arguing for the affirmative side is the University of Batangas. From the university in pursuit of knowledge, values, and skills, the next generation lawyers from the University of Batangas.
I am a goal-oriented person. When I enter into a venture, I make sure that I produce the best outcome possible. I took up law school because I believe that now more than ever I can contribute something, not necessarily to the entire system, but at least to the community.
I believe that I am fighting for what I believe is something that is right. I took up law because this is my ultimate goal in life. I am also seeing myself in the next few years as being part of that that legal profession that is rendering public service to those who are oppressed and the needy.
I'm a generous person, and I am kind, generally kind to those people who need help. I took up law because I'm the first in the family to go to law school, and I want to make my relatives proud. In law school, it's not just about reading and sharing or reciting cases or reciting provisions of the law, but you also learn how to communicate. You have this kind of empathy towards other people that no other people have.
Team University of Batangas. Spirited, intellectual, tenacious. And taking on the negative side is Beda University. Committed to the battle for the greater good, the Red Lions of Beda University.
I'm always the type of person who's very much passionate with what I'm doing, and I make sure that every time I go into an issue, that I put myself into the shoes of the abused. Taking up law has always been a dream of mine. With the practice of law, it is where I could practice my skills even more, and this is where my interest really lies.
Ever since I was a kid, I wanted to go to law school because it's a dream of mine. And now that I'm here, I am very passionate to graduate from Beda University and practice law in the future.
I'm a second-year law student, interested in the craft of debating. Otherwise, I'm just your average Joe. As I've always believed, people are a product of time and circumstance, so I don't see my decision in taking law as a consequence of a special decision, but rather a product of time and circumstance.
Team Beda University. Wise, humble, committed. Now let's meet our distinguished judges. First off, we have attorney Richard Hendrik Beltran, senior associate at the V&A law firm. Next, we have attorney Ferdinand Casif. He's a lecturer at the Philippine Judicial Academy and Center for Global Best Practices. And presiding as our chief adjudicator is Judge Princess Bustos Oqueco, presiding judge of the Regional Trial Court Branch 91 in Santa Cruz, Laguna. We're using a modified Oregon Oxford format. The debate is between two sides, the affirmative and the negative, with 3 members each. Each debater from the affirmative side argues the necessity, beneficiality, and practicability of the proposition, while the counterpart debaters on the negative side oppose these arguments. Each debater is given 4 minutes to deliver a constructive speech and rebut the previous argument. Each debater is given 2 minutes to interpolate or cross-examine the opposing debater. Only categorical questions may be asked. Each of the judges may ask 1 question of each speaker within that speaker's time limit. The judges score each team in terms of manner, matter, and interpolation. The team with a higher score from each judge gets a point. The team with the most number of points wins the debate. The chief adjudicator rules in the event of ties, objection, or contestation. This week's proposition, let it be resolved that the revocation of Senator Trillanes IV's amnesty is invalid. First up, for the affirmative side, we have Francis. Francis, you've got 4 minutes to tell us why the revocation of Trillanes' amnesty must be deemed as invalid.
Your Honors, good day. Before we proceed, let us assume for the moment that Senator Trillanes, in fact, did not file for an amnesty application and did not admit his guilt. Let us further assume that there is, in fact, a defect in the grant of amnesty to Senator Trillanes. If Senator Trillanes' amnesty would be declared void ab initio and thus revoked by, say for example, singer-songwriter Eastwood City Walk of Famer Ray Valera, there could be no other conclusion other than such revocation is invalid for the simple reason that the maging sino ka man singer is not authorized by our legal framework to effect the revocation. In the same manner, the affirmative side submits that the revocation of Senator Trillanes' amnesty by virtue of Presidential Proclamation number 572 is invalid for the simple reason that the President has no authority to do so. First, the President has no authority to order the revocation of amnesty effective immediately without the concurrence of the majority of the members of the Congress, as I will be discussing. Second, the President authority to enact an ex post facto law to be argued by our third speaker. As our first argument, Your Honors, the President has no unilateral authority to revoke an amnesty. It is true that the Constitution does not provide that a revocation requires a congressional concurrence. But isn't it also true that the Constitution did not provide that an amnesty can be revoked? Does this mean that an amnesty is irrevocable? The answer is no, in view of necessary implication as held in the case of Chavez versus PEA. The Supreme Court therein espoused the doctrine of necessary implication exists in order to fill the gaps and to resolve the obscurity of any given law, including the Constitution. In view of the same doctrine, Your Honors, it follows that the President's power to revoke amnesties is a power exercised jointly with the Congress. This is in line with the principle of separation of powers and systems of checks and balances. In People versus Patriarca, it is said that pardon is a private act of the President and therefore he can exercise it alone, while the grant of amnesty is a public act and must be done concurrently with the state or the public. This leads me now to my last point, that an amnesty is an act of the sovereign, that is, the people, merely partaking the nature of an executive clemency, the President being the mere instrumentality thereof. That the revocation of amnesties, Your Honor, becomes a foregone conclusion with the concurrence of the Congress, in view of the Court's declaration in People versus Makadaig, that the amnesty is in the nature of a law and has the force and effect of a law. It is a bilateral act of the executive and the legislative department, and this clearly manifests the shared powers between the Congress and the executive and the blending of powers, elucidating that although separate, governmental branches must work interdependently to deliver its Yes, Your Honor.
Counsel, if the Congress will subsequently concur with the revocation of the amnesty, would you agree that the amnesty now is considered, the revocation of the amnesty now is considered as valid?
Thank you for the question, Your Honor. With the revocation of the amnesty, if duly concurred in by the Congress, yes, we submit that therefore the revocation of the amnesty is therefore valid. Proceeding, Your Honor.
2 minutes now for the cross-examination.
Good evening, Counsel. Good evening. Counsel, just to be clear, are you familiar with the stages of amnesty?
Yes.
Alright. So you know the stages. So remind me, the one revoked recently was against Senator Trillanes, right?
Yes.
So to be clear, this is about the implementation, not the general grant, correct? It's about the implementation, correct?
Yes.
Of course, so we now know that it is clear that the President did not revoke Proclamation 75, but only a defective implementation. So, Counsel, is the power to grant an amnesty in Article 7?
Yes.
Well, so it is an executive power, correct?
Yes.
So, Counsel, do you remember when the grant of amnesty was given by President Aquino?
Yes.
Now, do you remember when Senator Trillanes conditionally admitted his guilt? It is in 2011, Counsel. So, Counsel, when the amnesty was granted, Senator Trillanes has not unconditionally admitted his guilt, correct?
No, that is beyond the issue at hand.
It is exactly the issue at hand.
No, the issue at hand is the validity of the revocation of the Trillanes amnesty.
So it was provided there that the applicants should have committed the crime, correct?
But it is irrelevant, Counsel.
It is relevant, of course.
No.
We are hinged on factual circumstances, Counsel. So, Counsel, may the President declare martial law?
I'm sorry?
May the President declare martial law?
Yes.
When he does, can he subsequently revoke it?
Yes, but subject also with the concurrence of the Congress.
Yes, Counsel. Is it a grant of amnesty an executive act, Counsel?
Yes.
So now we know, Counsel, that an executive act may actually be revoked. Continuing, Counsel, does the Constitution provide for an express provision on the revocation of amnesty?
No.
Of course. So, Counsel, can you think of any limitation on the power of the President that is not expressly provided for by the Constitution?
But the Constitution is not rigid, Counsel. It
We all know that, Counsel.
implication.
That is why the Constitution may only be limited by those expressed. This is an express law.
That's the policy, Counsel.
Okay, Red, you've got 4 minutes now to rebut Francis and to advance your argument on why the revocation of Senator Trillanes' amnesty is indeed valid.
Retaining what has been wrongfully given is a direct mockery of the rule of law. Your Honors, to clarify, amnesty had 3 stages. The general grant to all offenders through Proclamation 75, the concurrence of Congress, and finally, the determination of compliance with conditions set by amnesty. This debate is not about the revocation of Proclamation 75. Rather, this is the last stage concerning the revocation of a defective executive finding by the past administration in granting amnesty to Senator Trillanes. Team San Beda University is proud to defend that a determination of the compliance of the conditions of amnesty is an executive power. Hence, President Duterte acted within his constitutionally granted authority. We have 2 points to argue about, Your Honors. First, the President has the inherent power to revoke a defective grant of amnesty. And second, the unconditional admission of guilt required in the grant of amnesty has not been complied with by Senator Trillanes, as cited in the case of Pepsi-Cola versus Secretary of Labor. The doctrine of necessary implication means that every law is deemed to contain all such provisions as may be necessary to effectuate its purpose. We know that the President has the power to grant amnesty, and in accordance with this doctrine, it includes 1, the power to choose to whom the grant will be given, and 2, the power to make executive findings if the applicant properly complied with the conditions set. If there is a finding that the grant is tainted with an infirmity, then the President has to revoke this defective grant to truly effectuate his power to choose. This is in direct opposition with the first Yes, Your Honors.
Counsel, is there something in the Constitution, particularly Article 7, which grants the President power to revoke an amnesty that was previously given by a former President?
Your Honors, I understand your concern, but the thing is, implied in the doctrine of necessary implication is that the power to grant amnesty to the President also includes the power to determine compliance or non-compliance with the conditions set by the amnesty. And in this case, there is non-compliance which the President has the authority and has the duty to revoke. Continuing, Your Honors. This is in direct opposition of the first argument of the affirmative. This is not an ex post facto law because it is only as regards the determination of compliance or non-compliance of the conditions set. Yes, Your Honors.
Does President Duterte also have the power to revoke the presidential decrees issued by President Marcos?
No, Your Honors. What we have here is that we are saying that the President has the power to revoke the defective executive findings that we had in the past administration. Continuing, Your Honors, moving forward. Your Honors, the unconditional admission of guilt required in the application for amnesty has not been complied with by Senator Trillanes. He did not comply with an essential requirement set by Proclamation 75 as recommended by Concurrent Resolution Number 4 to have an admission of guilt. Amnesty overlooks and obliterates the offense with which he is charged and stands before the law as though he had not committed any offense. This is why, as stated in the case of People v. Beda, an unqualified guilt is an inherent condition in the grant of amnesty. However, in 2011, Senator Trillanes gave a qualified admission, saying that he only admits to the commission of common crimes and not to the charge of coup d'etat. This is in contrary with the doctrine in the case of People v. Magad, wherein it was said that it is the essence of the plea of guilty that accused admits absolutely and unconditionally. Concurrently, in the case of Kapunan v. CA, amnesty was initially granted to Kapunan but was subsequently nullified because there was a finding that he did not comply with an essential requirement of the grant. It was ruled in this case that the erroneous filing of application will exclude the applicant from the grant. And consistent with these, if Senator Trillanes fails to comply with the conditions as he did.
2 minutes now for the cross-examination.
Good evening, Mr. Speaker. Mr. Speaker, it is in your position that the amnesty granted to Senator Trillanes is defective, right?
Yes, Your Honor. Yes, Countess. It is in the definition of compliance or non-compliance of...
Please just answer the question, yes or no. But, and this is because of certain defects with regard to application requirements, correct?
Of course, it is. There is an unconditional...
And you presume that the revocation done by the President is the proper way to revoke an amnesty previously granted, correct?
Well, this is as regards to determination
please answer yes or no?
Yes, of course. But there's
okay, very good. Now, expressly stated in Article 2 or Article 7, Section 19 of the Constitution that the amnesty grant shall be with the concurrence of the majority of the members of the Congress, right?
Of course.
Would you agree with me then, Mr. Speaker, that this provision has its intent and its purpose?
Of course, it has its intent. I only asked to the grant
The framer should have not indicated if there is not a purpose, right? Answer the question yes or no, Mr. Speaker. Just yes or no, Mr. Speaker.
I already said qualified yes, Council.
And as we know, the intent of the Constitution, or the intent of the Constitution in requiring congressional concurrence is to promote the checks and balances in the Constitution, right?
As to the grant, but only if concurrence.
Okay, thank you. Because if there is no such mechanism, then the grant of the president to the president's power to grant amnesties is subject to abuse, right? And unbridled discretion, correct?
That's really speculative, Council. That's your opinion.
No, answer the question. Is it possible that it is that it should be subject to abuse, right?
Maybe, maybe not.
That the concentration of powers is subject to abuse, right?
Maybe.
Okay.
That's your opinion.
I'll take that as a yes, Council. True. But, Mr. Speaker, without the congressional concurrence, a revocation of amnesty is subject to abuse. Number 4, your question, Your Honor.
Let's now hear from the second affirmative speaker. Arnold, you've got 4 minutes to tell us why it would be beneficial to deem the revocation of Trillanes' amnesty as invalid.
Your Honor, good day. Points of rebuttal before I proceed with my constructive. We cannot countenance the argument of the negative that it is inherent in the power of the President to revoke the said amnesty. The Constitution is silent as to the issue of revocation, and indeed, we should apply the rule of statutory construction, which is more in keeping with the non-transgression of the principle of the checks and balances, which is the doctrine of necessary implication being pushed by the affirmative side. Second point, Your Honors. Anchored on the non-admission of guilt is the contention of the negative side. However, this non-admission of guilt are factual findings, Your Honors. Thus, they are questions of fact and within the proper forum of courts. And the executive branch has no power to derogate upon itself a power within the forum of the courts. And therefore, we are not to tackle here, and it is irrelevant on the issue to tackle as regards to said factual findings, because we are arguing as regards the non-authority of the President in revoking the said amnesty. It is clear that it is a battle cry of the affirmative side that the revocation of Senator Trillanes' amnesty is a deprivation of substantive right without due process of law based on the following. First, by grant of amnesty, substantive right that touches to person. Second, the right to be heard was not afforded to Trillanes. And third, questions of fact are within the province of judicial determination. As to my first point, Your Honors, even if it's true that by grant of amnesty, there's no vested... Yes, Your Honor.
If President Duterte himself granted the amnesty, does he also have the power to revoke it?
Your Honor, it is in line with the Constitution that such power is within the President, but it should be concurred by the Congress. It is a shared power, Your Honor. Your Honor, it is consistent with the Supreme Court's ruling in Enrique v. Legascami that a person has a right and protection that must be protected against the state. Second, Your Honors, the deprivation of Trillanes' substantive right without due process of law is evident on the fact that the right to be heard is not even afforded to him before the said substantive right was outrightly taken away. The Supreme Court in the case of Molino versus Court of Appeals provides that due process of law requires fairness by giving the person subject of deprivation a sense of rational participation in a decision that can affect his destiny. Your Honors, to uphold the subject revocation is to enunciate that by a mere executive proclamation, substantive right already enjoyed can now be taken away without affording a person the right to be heard prior to the issuance of the proclamation. That is a clear desecration of the spirit of the rule of law and even the due process of law. Last, Your Honors, the subject revocation is based solely on the factual findings of the executive of the non-admission of guilt as well as the non-filing of the application. However, these are questions of fact as I have mentioned, and questions of fact as stated in Litas versus People are within the forum of judicial determination, and to whom the Constitution granted the said power, it is within the judicial department as provided under Article 8, Section 1, and therefore, it is not for the executive to derogate upon itself a power or function which is not within the its forum, but it is within the forum of the courts. And therefore, the subject revocation may set a dangerous precedent because the substantive substantive right protected by the Constitution, and even the international covenant on civil and political rights will be obliterated and put into naught. With that, Your Honors, I am now ready for my interpellation. Thank you.
2 minutes for that cross-examination.
Good day, Counsel.
Good day, Mr. Speaker.
So remind me, were there any conditions attached to the grant of amnesty to Senator Trillanes?
Yes, Speaker. Yes, Mr.
Okay,
Speaker.
thank you for your
And
yes
that are
answer.
factual
Just to be
findings and
clear,
questions of
is
fact.
this your case that Senator Trillanes did comply with said condition, i.e. he admitted his guilt?
We are not to tackle the said
Okay,
factual findings
so
because
I
we
have
are not
here
the
a
court
copy
here.
of Senator Trillanes' interview in 2011 where he said that he would not admit to the crimes he was charged. So are you aware that in People versus Magat, it requires that the admission of guilt should be unconditional?
Mr. Speaker, that is
It's a
irrelevant
yes
because
or no
it is a question of fact.
Okay,
As
so can
stated
the
in the Class
state
versus
grant
People.
amnesty without compliance to the conditions?
No, Mr. Speaker.
Of course, no. Okay, so you mean to say that Trillanes was granted amnesty without admission of crimes and thus not complying to the
Still,
conditions?
Mr. Speaker,
Okay,
that
let's
is
move on to the
irrelevant
next
because it is a
question.
factual
So
finding,
is it
hence
your
within
case
judicial
that the
determination.
President does not have the power to revoke amnesty?
It has the power, but with the
Okay,
concurrence
so
of the
the
Congress.
grant
A
of
shared power,
amnesty
Mr.
is
Speaker.
found in Article 7, Section 17 of the 1987 Constitution. Am I
The
correct?
provision is silent, Mr. Speaker.
Okay, so now, actually that's my next question. Can you now cite the pertinent provisions of the Constitution which state that an amnesty cannot be revoked?
Mr. Speaker,
So
we can
therefore,
imply-
there is no constitutional mandate
we can imply
that
interpret that
stops
it's
the
a shared
President
power
from
between the
exercising
Congress
that
and the
power.
President
So is it your
to uphold
case
the checks
that
and balances.
the revocation of amnesty is a violation of due process of law?
Yes, Mr. Speaker, because Trillanes was
so
not given the right to be heard
I would
prior
say
to
that
the
you are
issuance
well
of the
versed in the
proclamation.
context of due process. Are you aware of the two requisites of due process, which is notice and
Mr.
hearing?
Speaker, the speech contains
Okay, so
due
tell me,
process as a minimum
counsel.
requirement
Tell me,
of
counsel.
being
As
fair.
of today,
A
is
fair-
Trillanes a free man?
Mr. Speaker, that is a factual finding.
Joel, you have 4 minutes to rebut Arnold and to advance your argument on why it would not be beneficial to consider the revocation of Trillanes' amnesty as invalid.
Good day, Your Honors. Lodged on the President is the duty to ensure the faithful execution of laws, and with it to overturn with urgency its wrongful implementation. Your Honors, 2 points for beneficiality. First, it is beneficial that the President can revoke amnesty to faithfully execute laws from which delinquent guarantees were made immune from. And second, depriving the President the power to revoke allows people to easily circumvent the purpose of amnesty and making it less effective. So going to my first point, Your Honors, under our penal laws, if a person commits a political crime, he will face the consequences of the law such as prosecution, incarceration, liability for damages, and imprisonment. Amnesty shields that person from all these and the general coverage of laws that should otherwise apply. There are numerous instances, including the case of Senator Trillanes, where the grantees of amnesty are able to enjoy the privilege of this act of grace even though they did not comply with the requirements. This is where the problem comes in. These political offenders are erroneously shielded from the consequences of the law. As response to this problem, Your Honors, it was held in Lagman versus Beda that it is beneficial to allow the President the leeway to revoke erroneous grants of amnesty so that the political offenders may be properly brought under the shackles of justice. This is in line with the constitutional mandate, Article 7, Section 7. Yes, Your Honor.
Madam Speaker, if the amnesty was already granted by the former president, wouldn't we say that there was a presumption of regularity that Senator Trillanes formally admitted as to the guilt, as to the commission of this crime?
Yes, Your Honor, we understand that concern. However, in this case, it was proved upon executive finding that there was a defect in the application of the amnesty. Therefore, we cannot assume regularity because in the first place, he did not admit his guilt, which is a requisite for amnesty. So, tying that back, Article 7, Section 17 of the Constitution, the President shall ensure that the laws be faithfully executed. Your Honors, if you don't give the Chief Executive that power, then those who are erroneously shielded from the law will continue to walk among us because of their erroneous immunity from from its coverage. Therefore, the benefit is we give the President a weapon to properly... Yes, Your Honor.
Are you saying that the basis of the revocation is from an executive finding?
The revocation of amnesty was found in the executive finding because it was inherent in the executive to examine whether or not the grantees of amnesty have complied or did not comply with the application of amnesty. So for my second point, Your Honor, if we deprive the President of the power to revoke, then people can easily circumvent the purpose of an amnesty, making it less effective. Your Honors, the purpose of amnesty is to grant genuinely willing individuals to be integrated back to the society and ensure national healing. In turn, we impose strict conditions to ensure willingness to reconcile with the nation. First, the filing of the application, and second, the admission of the guilt of the crime committed. If we let political offenders to continuously enjoy the irrevocability of amnesty, even without strict compliance, then political offenders will realize that it is not necessary for one to have genuine willingness to reintegrate and change in order to enjoy the benefits. While we concede that it is a peacemaking tool, it should not be handed out recklessly to the extent that we allow people to acquire privileges of amnesty without complying to the conditions of the state. It waters down the very purpose of why amnesty is being used as a tool for national healing.
2 minutes for the cross-examination.
Mrs. Speaker, it is in your contention that there is no violation of due process because of Trillanes' non-admission of guilt, correct?
No, it was because he was given notice and hearing because
that
of
is
the
your
prerequisite
contention.
of due
Such
process.
non-admission, which is the basis of your contention, is a question of fact, correct?
Of course.
Yes. And subject to judicial determination, correct?
No, because it is an
Yes, Mrs.
executive
Speaker, under Article 8,
finding because
Section 1 of
it
the
is
Constitution,
inherent upon
the
the
judicial
executive.
determination or judicial powers vested within the Supreme Court or the lower court as established by the law, correct?
This is an executive
It is, Mrs.
finding.
Speaker. And as such, the function of the judicial determination is within the courts and not the executive, correct?
No, it is not within the court.
It is, Mrs. Speaker. That is why your contention is a mere speculation because there is a protection to be granted because the court will have the power to check this or to check if there is a violation.
So are you saying that there is no check or balances if the power is in the
that you
executive?
are contending? Second pointer, Mrs. Speaker, do you know what political crimes are?
Of course.
It includes rebellion and coup d'etat, right?
Of course. What's your point?
From Proclamation 8, Series of 1946 to Proclamation 75, Series of 2010. These crimes are subjects of amnesty, correct?
Of course.
Very good, you've done your readings. The purpose of such is to promote an atmosphere conducive to the attainment of comprehensive and enduring peace, correct? And that is in line with your contention.
Conceded it is for national
legitimate interest, Mrs.
But
Speaker, correct?
Senator Trillanes
This is a legitimate
do not want to be integrated back into society by
But
not...
please answer the question.
What's your
This is a
question?
legitimate state interest, correct?
Of course it is a legitimate state
Then by
interest.
voiding the said amnesty will be tantamount to desecration of the said legitimate interest. Hence, you are fully speculating.
Let's now hear from the third affirmative speaker, Melinda. You've got 4 minutes to argue the practicability of considering the revocation of Senator Antonio Trillanes' amnesty as invalid.
Today we tackle a monumental issue which delineates the extent of the powers of our democratic government leaders. Powers that define what can be done, how, and to whom. Your Honors, ladies and gentlemen, allow me to refute the arguments of the negative bench before I proceed to my constructive. It is their position that if there are existing defective acts of the executive, it can be determined by the executive itself. To determine if an executive act is defective should not be conducted by the same branch because this would be a violation of the principle of checks and balances. It would as well undermine the powers of the judiciary. Acts which amount to grave abuse of discretion should be left to the Supreme Court or the lower courts to decide. It is also the position of the negative bench that if the Constitution is silent, if it is not expressly provided for in the Constitution, it should not be upheld. We disagree.
truth and in fact, there are a lot of existing jurisprudence that are not based on an express constitutional provision, but they are effective, nonetheless operative. Invoking casus omissus is not applicable in this issue. If the application of casus omissus will result to incongruity and a violation of the Philippine Constitution, then the doctrine of necessary implication must prevail. Moving on. To summarize the points of the previous affirmative speakers, the revocation is invalid because the President is not authorized to do so unilaterally, and it denies unto the Senator the right to due process. Like the grant of amnesty, revocation must be concurred by the majority of Congress to be consistent with the principles of checks and balances. Further, the right to be heard was denied prior to the said revocation. He was not afforded the opportunity to refute the allegations therein. This leads to our final argument. Proclamation number 572 is unconstitutional for being an ex post facto law. This would raise a very important question. Does the prohibition on ex post facto law apply to presidential proclamations? The answer is in the affirmative. In the case of kay Villegas, yes, Your Honor.
A license, say, given by the LTFRB in favor of a franchisee, upon violation may be revoked by the grantor of that license. Is this different in the case of amnesty? Can it not be also revoked by the person who granted it?
Licenses are revocable, that is correct, Your Honor. However, in this case, wherein factual determination has not yet been achieved, to revoke is premature. There needs to be a determination whether or not there really is a compliance or non-compliance in the requirements in order to adjudge the validity of the subject proclamation. To proceed, in the case of kay Villegas kami, it was held that an ex post facto law is one which deprives a person accused of a crime of some lawful protection to which he was entitled, such as the protection of a former conviction, of an acquittal, or a proclamation of amnesty. This doctrine has been repeatedly cited by the Supreme Court in several cases, including but not limited to the cases of Nunez and Magbanwa. Proclamation number 572 is unconstitutional because no form is required for an act of the government to be considered as an ex post facto. This is consistent with Cummings versus Missouri as cited in Osmeña versus Tendatum, which held that a depriving...
2 minutes now for the cross-examination.
Counsel, are you aware that the Department of Agrarian Reform grants lands to certain farmers subject to conditions? And the DAR determines if there is compliance, correct?
Yes, that's correct.
Are you also aware that the Bureau of Immigration grants visas to foreign citizens subject to conditions?
Yes, that is correct.
And the BOI also determines if there is compliance.
That's correct as well. And your point,
Are you
also?
aware that the DND oversees the grant of amnesty in Proclamation number 75?
That's correct.
In all these cases, Your Honor, the DAR, the BOI, the DND are all under the executive, and the determination of compliance or non-compliance is a quasi-judicial function of the executive. Would you agree that compliance with the application is a factual issue?
Yes, very, very much.
Do you know the doctrine of exhaustion of administrative remedies?
Yes, I agree as well.
Where
However,
one should
counsel,
avail all the means of administrative processes provided by law before seeking the intervention of the court. Then it is correct that the DND
however,
first
counsel,
made a
if there
finding
is
of
the presence of
non-compliance.
grave abuse of discretion, this
framers
is not in the hands of the executive anymore. If there is a
Counsel,
presence of grave abuse of
Do you
discretion,
agree
it
that
is
the power to
for the
grant
courts to
includes
decide.
the power to withdraw? Does
That
the
is
power,
not an absolute rule, sir.
and by necessary implication, as you argued earlier, it is deemed to contain all such provisions necessary to effectuate such laws, and this power is vested within the
As
executive.
long as it is not
the grant of
contrary to
amnesty
the
a contract?
Constitution.
Counsel,
I'm sorry, sir?
is amnesty a contract?
In a way, yes.
And the perfection of which is subject to the fulfillment of conditions which in this case was not complied with. Is it an act of clemency?
Your Honor, we are not here to argue
Is
whether or are not...
an act of clemency?
Yes, it is.
Are you aware that it is incumbent upon those who avail to prove that they are entitled?
But all of these are factual
Any
issues
doubt
which is
in the
not
application
the purpose
is
of this
resolved
debate.
against
The
the
purpose of this
applicant.
debate,
She's
Your
not
Honor,
being
is to
responsive,
argue
Your
on...
Honor.
Okay, Nicola, you've got 4 minutes to rebut Melinda and to advance your argument on why the proposition to deem the revocation of Trillanes' amnesty as invalid is not practicable.
In defense of the Republic, Team San Beda submits the determination of compliance with amnesty is an executive power. 2 points in this speech, Your Honor. Firstly, the power to revoke is more practicable when it is exercised by the executive. Secondly, responding to the entire case on the cost of eroding amnesty. Before that, a bit of clarifications. We say that the source of executive power to grant amnesty is vested in Section 19, Article 7. Yes, the Constitution is silent, but by virtue of necessary implication and by virtue of its residual powers, it is vested with the executive regardless of whether or not there was Congress concurrence. First point, side affirmative argues, Your Honors, that it should not be solely exercised by the executive and should be subject to Congress concurrence to uphold the value of checks and balances. Checks and balances still exist in our House because should there be a finding of grave abuse of discretion, they can file through Rule 65 of the Rules of Court. Whereas, we argue that it should be exercised by the executive because it is the best arbiter in matters involving amnesty.
Based on the answers of the University of Batangas, they say that a factual determination is a condition precedent to a revocation. Do you agree?
Yes, Your Honor. And in this case, it was performed by the executive. They found a finding that there was no compliance to begin with. Thus, the revocation was valid. It was a quasi-judicial function. The grant of amnesty is impressed with political questions. It is a matter of national security, which is an issue directly handled by the executive. The executive has a wide array of resources on the subject matter, otherwise not available to the other branches of the government. To illustrate, Your Honors, the entire prosecutorial arm of the state, the Department of National Defense, the AFP, and others.
Counsel, you're saying that the basis for the revocation of the amnesty is the residual powers of the President. Could you please enlighten us what are those residual powers?
Your Honors, as ruled in the case of Marcos v. Manglapos, if a power is not expressly stated in the Constitution and it cannot be found in the legislative, nor can it be found in the judiciary, it is deemed to be exercised inherent within the executive. Absolutely, Your Honors. In this case, without Congress concurrence. Which means, in connection with why the executive has a wide array of resources, the findings of the executive as to sufficient grounds for revocation is a result of efficient and accurate fact-finding from different agencies of the executive, unlike the Congress, which has a limited pool of information. But subjecting it to Congress concurrence would be subjecting it to the politics of Congress. If there is indeed a sufficient ground for revoking, you would still have to go through the cumbersome process of lobbying each member, tallying the votes, which may or may not attain the majority vote. What is the cost of not vesting this power with the executive? In the case of Rizos Vidal v. Comelec, it is quoted, these limitations contribute toward the creation of an anti-president constitution or a president with vast responsibilities but no corresponding power. It hampers the executive's capacity to faithfully execute the laws. Point 2 on the erosion of amnesty. Side affirmative argues that amnesty should not be revoked because it discourages political offenders from accepting an amnesty from the administration. Whereas, Your Honors, we argue that revoking is necessary to correct an infirmity in an application and to ensure that the meaning of amnesty is upheld. The significance of amnesty is not determined by the number of grantees who accept the amnesty, but by the genuine willingness to reform back to society. More importantly, political offenders.
All right. 2 minutes now for the cross-examination. Hello, Mr. Speaker. You're aware that the Senator assailed Proclamation number 572 before the Supreme Court.
Yes.
And the Supreme Court has pronounced that the petition of Senator Trillanes
should be remanded
to the lower court.
Yes.
Okay.
Now, cases are remanded to the lower courts for determination of facts, correct?
Yes.
That being so, your position that the revocation is valid has been totally defeated.
In fact, they even argued that
My
it
next
should be
question,
determined by the
Mr. Speaker,
executive.
you have
particularly
mentioned the case
ANC.
of Marcos versus Manglapus.
Yes.
And in this case, diminution of powers of the president was also discussed. Am I correct?
Yes.
Now, the diminution of the powers of the president has in fact happened as an aftermath of the Marcos administration, correct?
Yes.
The aftermath of the Marcos administration is a living proof that concentrating too much powers on the executive is prone to
That doesn't
abuse.
defeat the argument
No
that
more further
there's
questions.
residual powers.
Thank you.
Let's now hear what our judges have to say about our debaters. Attorney Beltran, how did the affirmative side of the University of Batangas do?
Congratulations to the debaters of the University of Batangas for coming prepared for this battle. I would have appreciated more research, more in-depth research, and contrary to your to what you said in your speeches, I think that the factual circumstances for this particular topic is very relevant and should have been tackled during the debate. Good luck. Thank you.
And Attorney Cassis, how did the negative side San Beda University do?
The negative side presented a logical argument, considering that essentially they're saying the one that grants it may revoke what it has granted. Thank you.
Now let's hear from our Chief Adjudicator, Judge Oseco. Your Honor, who did the judges pick for Best Speaker?
Best Speaker goes to Jaime Nicolay Bagaw.
And the school that won this round?
Best School for this round, the San Beda University.
A big congratulations to San Beda University for winning the second round of Square Off Season 16 Affirm Debate. I'm Mike Yoreta. Thank you so much.